would say that, unfortunately, we couldn't find much of the discussion of the CPM ends up appearing in law journals, and there's a sort of this should or this should not be there. The one piece we did find was these perceptions of autonomy among physicians, and that's where we did not see a difference in perceptions of autonomy between those physicians who were employed and salaried and those who were not. We couldn't find sort of a larger, we couldn't find a larger analysis to really understand whether outcomes were particularly different. And I think part of it simply is because there are so many interdependencies, and this is one piece of it. And I think in some ways, to go back to what you said in your opening statement, when this was created, it was a much less complex system. It was about a physician. You had corporations and you had physicians, and you had their clients, their people, right? But today, we have all of these other players in the marketplace who also exert a lot of control, and sometimes that may be at the same level or as much as perhaps an employer could.
Right. And you basically answered the question. The other one that I had was, have you found evidence in states with with bans, do they show better patient care and lower costs than the others? And I think you indicated that they don't. We
would have loved to. I think there are too many different variables for this is something that we did look for, and there were simply too many different variables. I think you had a lot more people who were researching the impact of insurance and how the sort of actors in the insurance marketplace and what result that had on patient care. But you had, we really couldn't find anything that looked at employment. It just wasn't at the top of anyone's research agenda.
Very good, thank you. Senator Bates, any questions?
Very interesting.
It is fascinating. Well, thank you very much, Ms. Neville. It's outstanding report, very thorough. Ms. Juniper. Welcome. Good afternoon. Thank you for being here today and giving us your perspective.
Thank you for having me. So Chair Hill and Vice Chairwoman Bates and other members of the committee. My name is Kitty Juniper, and I'm a healthcare attorney with Buckhalter Niemer and their healthcare practice group. We are a California-based law firm. I've lectured and published nationally and locally about the corporate practice of medicine, but more importantly, we have many, many clients who we advise on these issues on if probably a daily basis, quite frankly. So some of these include medical groups, clinics, national retail companies, optical companies, especially healthcare plans, telehealth, device companies, imaging facilities, non-physician practitioners, and many, many other type of healthcare providers and businesses. At the committee's request, I'm here to provide a very brief background on our practical experience with CPOM issues and to comment on the report that was just published. I do congratulate the authors because it's a very complicated area of law, and I thought they did an excellent job in succinctly summarizing it. So I'm not here to advocate for or against CPOM. We have clients on both sides of the fence. We have some clients who vigorously defend the corporate practice of medicine doctrine. We have other clients who think it's inefficient, that it gets in their way of doing business, and it is impractical. So, I've seen both sides of that. But what I'd like to touch on quickly today, I think I have 10 minutes, and I usually would lecture at least an hour on this subject. So, the breadth of CPOM doctrine in California, the typical business solution, which is a management services arrangement, and then a couple comments on the report. So first of all, the breadth of the corporate practice of medicine doctrine. When we refer to CPOM, we're talking about more than the ban against lay entity employment professionals. And I'm going to refer to the lay entities as corporations today, and I'll refer to, since this applies to many different practices, medicine, dentistry, optometry, et cetera, as practitioners, okay, just generically. But in addition to dealing with and banning employment of practitioners and also banning corporate ownership of medical practices. It bars corporations from controlling practitioners' exercise of professional judgment and their delivery of healthcare services. So what constitutes the control of the practice of medicine is the subject of various court cases, various opinions by the Attorney General, and guidance from the relevant regulatory boards. A lot of it, most of it based on legislative history, but many times no specifics in the statutes. These interpretations are very broad, and business services that a business may typically provide to a business in another area are considered unlawful when they're provided in the medical profession. So courts have made it clear that in determining when there is excessive control so that it constitutes the illegal practice of medicine, they scrutinize not only controls that are exercised over the delivery of clinical care, but they also look at the extent of control exercised over a corporation's provision of the business services to the medical practice. And this is typically a fact-specific analysis. So corporations can't contract with practitioners to provide medical services on the corporate behalf. They can't hold themselves out as practicing medicine by having practitioners practice under their corporate name. They can't advertise on practitioners' behalves. They can't take a percentage of a practitioner's professional fees in exchange for the business services they're providing. And they can't make other decisions that California has determined are within the professional practice of medicine. I was going to comment on the case, but you already did, which is interesting, the one with Dignity and the ACLU, which I know that the CMA has intervened in with regard to the ethical guidelines of a Catholic hospital and whether or not they're not allowing doctors to do the postmortem sterilization procedures actually interferes with, doctor-patient relationship. So that's going to be kind of an interesting, I think, case to watch in that area. So, excuse me. While in theory, CPOM sounds like it's very straightforward. The medical board has different factors that you can look at. These cases have set forth different factors. When you go to apply them in the context of a new business, new healthcare product, new service, it ain't so easy to do. It does help us with our business, I must say, in the legal field, but it's still, we end up a lot of times going back to clients and saying, well, we think this, here's a gray area, do you want to take this risk or not, and trying to determine if they comply. One of the business arrangements that we typically would set up are management services arrangements. And that's because California law does not prohibit practitioners from contracting with corporate management services organizations. We refer to these as MSOs. The MSOs will help them run their businesses, and so long as they don't control the business to the extent that they are interfering with the professional judgment, again, of the practitioner, the corporations can provide these services. So for instance, when will we use that? Let's say that a telehealth company wanted to come into California and they wanted to provide telehealth services to California patients. First, they'd have to get around the telehealth laws, and they would have to hire California licensed physicians to provide the services. But then they would have to say, okay, we can't employ those physicians. How are we going to do this? Because they may have a national company operating under a branded name. In that case, they can't do it the same way. What they would do is they would find a professional medical group who would want to do business with them. They would then set up an MSO agreement, and through that agreement, they would provide services that would help them to look like the way they practice in the rest of the country, short of interfering with the medical practice that you can't do here. Again, in setting up those arrangements, we have to be very careful. We have to make sure that those arrangements do comply with all the indicia of control that aren't allowed here, that the medical board has said that you can't put into agreements, whether it's through fee setting, they can't set fees, you can't advertise under the corporate name, that sort of thing. Companies don't typically like it, but usually they will find a way to comply with it. They'll get, around it, and it may be difficult, especially when you have a retail mentality, quite frankly, when it's all about advertising and pushing sales, to finally step back and realize that, okay, we really have to respect that relationship. And I think a lot of that, too, is like doctors. You're talking about some doctors don't comply with their ethical professional standards. And I think some corporations are like that, too. But others understand it, and they, will abide by it. So just a couple comments on the 2016 report. The report discusses AB 684 and the recent changes to the optometry and the optical company laws, and it specifically addresses the landlord-tenant requirements therein. It also suggests that elements of those landlord-tenant relationship laws could be used as a model for other business relationships in the medical industry, such as retail clinics. I think it's important to clarify that AB 684 made changes to laws that previously prohibited the landlord-tenant relationships between opticians and optometrists. Those type of landlord-tenant relationships are generally not banned between physicians and retail entities, including opticians and optical companies. In fact, AB 684 recognized that and specifically excluded doctors and medical groups from its application. So I think that AB 684 should be viewed as a unique solution because there were several factors at play in that compromise legislation. I also think that applying those sort of landlord-tenant requirements as a model for business relationships would increase the requirements for medical groups lease where there may not be a need, as far as I know. I agree with the report's statement that CPOM requires that national retail clinics who want to do business in California change their usual business structure and operating practice. However, this goes beyond retail primary care clinics. For instance, telemedicine, as I've discussed, e-health device companies are growing and they're entering the state and they have to comply with the CPOM doctrine. The report also doesn't address employer-based healthcare clinics, which are also on the rise. So you might want to think about those sort of new trends in healthcare too. Finally, I would urge the committee not to impose new agency approvals with any of the changes that may be made that involve the CPOM doctrine. While the doctrine sometimes complicates business arrangements in healthcare, particularly where businesses are testing new products and services and trying to roll them out nationally, what will keep them out of the market in California are the delays caused by agency approvals, which can go on for months and months sometimes. These delays wreck their business plans and create uncertainty for their forecasting and otherwise. So thank you for allowing me to address this distinguished committee.
Thank you, Ms. Juniper. Appreciate the comments and your insight. You mentioned that you do have clients that are on both sides of the
That's
coin,
correct.
basically the different CPM policies. If you do, then are you aware that physicians practice differently in one over another?
Well, when you say they practice, if you're talking about their decisions as how to deliver medical care, I am not aware of that. Okay, and that could be just that I don't get down to that level, quite frankly. Don't do malpractice or anything like that. I know that employers may make decisions around them, and because the doctors don't have to get involved in some of the administrative areas, they can practice medicine if they're allowed to do it. So they don't have to deal with all the other crap around them that's required in the healthcare system.
Right. And then one of the issues that was raised, and I think is the retail of medicine or the storefront, and that there may be a problem in California because of the lack of more access that could be created by those as a result of the CPM and the challenges that faces. Do you see that as an issue? And it may be beyond your scope of understanding, or do you see that if that were a problem and CPM were a problem related to that, that there could be workarounds related to that issue and we could have greater use and access if possible.
I would say that we have dealt with those issues, and we have set up MSO arrangements for those issues for national companies. So they are using workarounds right now,
Okay,
so.
very good, thank you. No, very good. Well, thank you very much. This was insightful and very helpful. And again, thank you for the report. It's outstanding. So now we'll have our next panel, perspectives from physician groups and physicians. Bill Barcelona, Senior Vice President, Government Affairs at CAPG, and Astrid Megrigian, attorney on behalf of the California Medical Association. Good afternoon and welcome. Thank you, Bill. Thank you for being here today. This is great.
Long time. It's like old home week around here.
Oh, is it?
This is great.
It's been 10 years since I've been here.
In this building? Oh, my goodness, I admire you for that. And I think that's a good thing, if you can stay out of this building long time. So we'll start with you, Bill, if that works all right.
Thank you. Yeah, thank you very much, Chairman Hill and members of the committee. First, I'd like to compliment staff on the report. I thought it was very well done. I would like to make some additional comments about the report to kind of set the context for physician group testimony. So the interesting thing is about the lack of data in California. As you look at the report, it talks about how physicians are organized in California and where they practice and what types of practices they have. In that chart, in the report, my groups are not mentioned at all. And CAPG currently has 180 groups in its California membership. We have 210 nationally. We have groups in 44 states now. That's why we're no longer the California Association of Physician Groups. We're just CAPG. So this lack of data muddles the policy discussion, but I think it's important to your deliberations here in this context. Physicians have organized themselves in California to a somewhat higher degree than any other state in the country. You have a number of these physician groups. They are structured in two different ways. Multi-specialty medical groups are shareholder arrangements formed as professional corporations. And then you have another type of entity which has become popular in California called the Independent Practice Association. There are actually more of those than there are multi-specialty medical groups because they were formed with the idea of medical groups without walls back in the early 90s. They're loosely constructed networks. They have evolved over time, and they don't always have physicians who are exclusive to the organization. Some physicians out in the community could be part of 2 or 3 or 4 IPAs, for example. But over time, these IPAs have been evolving, and more now we see arrangements where the IPAs will have exclusivity provisions with a certain number of physicians in the network. And some of these, for example, there's a large IPA in Orange County, for example, Monarch Healthcare, where upwards of 60% of the physicians have exclusivity agreements with that IPA. So whether it's virtual or whether it's bricks and mortar, physicians are organized in this state around their own physician-owned and physician-governed operations. Now, Kitty Juniper's testimony was helpful from the standpoint that physician groups are also intimately linked with these management services organizations as well. Often they are owned by the same groups, the same physician groups, but they choose to organize in a way that the corporate side, the back office, if you will, is run by the MSO and not by the physician group. It does leave the physicians more able to practice medicine and leave the day-to-day complex business arrangements to another entity that may be operated by more administrative types than clinicians. So where does that leave us with corporate practice? Physician groups have had a tough time in the post-ACA era in terms of capitalizing infrastructure. And it's really a function of tax law, nationally and at the state level as well. physician groups are not organized to retain capital the way hospitals and health plans are. They're incented to pay out dividends to their shareholders at the end of the year or be taxed on that income. And so they have not been as well equipped in the post-ACA era to meet the challenges of the greater infrastructure that's needed to integrate and to provide coordinated care services. Although this has been their hallmark for the last 25 years, that they are organized and they have integrated. So it's a bit of a conundrum. And then you have the phenomenon of accountable care organizations. California has more accountable care organizations that are physician-owned and run than any other state. We had 6 of the 32 pioneer ACOs under the federal demonstration. We have a number of the Medicare Shared Savings ACOs as well. To my knowledge, none of those are operated in an employed model in California at all. They're mostly organized by physician groups or by integrated delivery systems that are hospital and physician group hybrids. They function very well. The choice of a business structure for them is not as important ultimately as the way in which the physicians are compensated within those organizations. And that's the point that I really want to make here today. How we drive value for consumers in California going forward in terms of cost and quality and accountability and transparency, I think is more dependent upon the payment mechanisms that you hold physician organizations to over the long term. And I think as we move away from pay for volume and move to pay for value, you will see more accountability, better performance by physicians over the long term. And that will enable them to organize and build infrastructure. In defense of that opinion, I can offer Professor Robinson, Jamie Robinson's recent paper in the Journal of the American Medical Association from about 2 years ago that studied outcomes in terms of cost and quality among physician groups that were physician-owned versus physician groups that were tightly affiliated with hospital systems. And I would recommend to staff that they read that paper closely. I didn't see it cited in the footnotes for the paper, but I may have missed it. I think that's an interesting study in contrast in terms of business models and what you can get out of one versus the other. So physician ownership, physician control is an important point that I think should continue to be preserved in California. And I'll conclude my comments with that.
Great. You know, a question to that. You certainly, I think, the physician group is a major part, obviously, of California healthcare today, and that fits in certainly to the continuum of care and the CPM aspect of that. I mean, that's kind of the driver for the whole aspect of it. But if we're trying to create greater access for healthcare or to provide more professionals with more care, and I know if I remember correctly, you were supportive of increasing the independent practice rights for nurse practitioners.
Yes, we were.
And without subjecting them to CPM and the ban. So how, if you support that for doctors, how do you distinguish these two practitioners or these different groups?
I think the distinction in our mind at this time is over, not so much over individual types of practitioners, but over corporate control of delivery systems. And systems that are owned and operated by the professionals who practice within them deliver better value for consumers over the long haul than systems that are owned by corporations and non-practitioner. So beyond that, I can't get any more granular. We haven't developed our policy on corporate practice since 2009 at CAPG. It's complex now because we've become a national organization. We have a lot of members who are non-California based and who actually operate in corporate practice states. So How we will develop our own policy in this regard, I really can't tell you at this point in time.
All right, thank you, Mr. Barcelona. Appreciate it. Thank you.